Good evening. My name is Stephen Leskin. I am a divorce attorney in Portland, Oregon, and welcome to my deep dive series. Once every other week or so, I take a topic in Oregon divorce law and spend about an hour talking about it. I don't take questions during the seminar or webinar, but you're more than welcome to give me a call or shoot me an email afterwards. And if you have questions, I'm happy to go through it with you. I just don't like taking them when I'm talking. But I'm happy to spend the time going through with you your particular situation. So the purpose of the deep dive seminar is to take a topic in divorce law and really spend an hour looking at it and uh, looking at it practically, looking at it from the perspective of law, looking at it from the perspective of a lawyer, and trying to figure out, you know, trying to elucidate what Oregon law is on any particular subject. Today's topic is actually an overview of Oregon divorce law, and I'll talk about the three big issues that are decided in any divorce trial and the three issues that you have to be familiar with. The first of those issues is the division of debt and uh, property, so assets and liabilities. So we'll spend some time talking about how Oregon law looks at dividing uh, debt and assets in a marriage. We'll then talk about future income and why that's important, because that forms the basis of spousal support. And we'll talk about the three different ways that a spouse might be entitled to spousal support by statute. And then lastly, we'll talk about children. And uh, it's very rare to have a divorce case where there's um, no assets and liabilities to discuss. Obviously, not everybody has children. So that's why I'm doing it in that order, because the assets and liabilities will touch everybody, whereas a fair amount of couples don't have kids. So with that, we'll get started. So let's talk about assets and liabilities. The Oregon law provides in the statute that the judge is required to make a quote, just and proper division of the assets and liabilities of the marriage. In a marriage, a spouse cannot act as a power of attorney for another spouse. So a husband can't go and buy a car in wife's name. You can't sign unless the wife has delegated a power of attorney to the husband. Husband cannot go and say, "I just bought a car for my wife." So there's this statutory um, regime that says that a couple's property remains separate during a marriage. However, once a couple gets divorced, it becomes a species of co-ownership, and that's what the statute provides is co-ownership, so that the court can make a just and proper distribution. The full language of the statute is a just and proper in all the circumstances, and the way courts interpret that is equitably, which usually means evenly, and evenly um, depends on the circumstances of an individual marriage. So, for example, in a short marriage where the parties are together a year, 2 years, maybe even 3 years, short marriage, the courts will try to put parties back into the position they were before the marriage so that nobody profits from the marriage and both come out with the same circumstances that they were in prior to the marriage. On the other hand, same short marriage, say same 3 year marriage. Supposing a couple buys one of the partners sells a house and puts the proceeds from the house into a new house, and then the parties commingle all their assets, right, and commingle all their accounts. In that case, the court's not going to divide things evenly. The court's going to try to put parties back into where the position they were before the marriage, if that's possible. So if the couple bought a new house, the spouse who put the down payment in from the proceeds from the sale of the premarital home will get that back. So it's the intentions of the parties that rule. That's evidenced by what the parties' conduct was during the marriage. I've had cases in the past where there's been long marriage, 10 years, 12 years, whatever, and the parties never filed a joint tax return. They never commingled their bank accounts. They never commingled their retirement plans. They didn't have wills. They didn't have wills that named the other spouse. Essentially, they were roommates, right, in those circumstances. And the court said, well, without demonstrating an intent to um, commingle assets during the marriage, without that intent, uh, the court would not do an equitable, meaning even distribution. The parties will retain in that set of circumstances their own individual property. So if somebody came into the marriage with a house and a lot of equity in the house, the court's not going to, if there's been no other division, then the court, I misspoke, no other commingling, then the court's not going to uh, evenly split that equity. Uh, the court typically, the court has the statutory authority, meaning the legislature has given the courts the authority to divide any asset in the marriage. So, in certain circumstances, a court could look to the premarital equity in a home and say, I'm going to split that up in order to get to an equitable division. But generally, as a general matter, uh, property assets that are brought into a marriage remain the possession of the person who brought them into the marriage. So, for example, if you paid off a home and the home was paid off and then you got married, the spouse would not have a claim to the equity in the home that's been paid off before the person married or the accruing equity later that accrued during the marriage. Uh, so the courts follow a case called Coons and Coons. It's an important case in Oregon law because it lays out the court's framework for dividing property. The public will never hear about this. If you're litigating a divorce, you won't know about it. But all attorneys know the case of Coons and Coons. Some people pronounce it Coonsy. I don't know. I call it Coons. Um, Nobody's smacked me in the head yet and said that I'm pronouncing it wrong. But that may happen. And Coons said that the way to determine just and equitable is to first figure out what was premarital and what was acquired during the marriage. If it's acquired during the marriage, it's going to be, if it's acquired uh, prior to the marriage, it's going to be set aside. And then the court will look to divide things evenly unless there's an exception that can be made. And the exceptions like revolve mostly around the intent of the parties as evidenced through commingling or um, a spouse who fails to provide an equal contribution. And an equal contribution may be such that um, um, one spouse pays everything in the house, right? One spouse pays the repairs, the utilities, uh, um, the taxes are filed separate, joint married filing separately. In those cases, the one of the spouse may overcome the presumption of equal contribution. And under Coons, if you overcome that, and that's reflected in the statute, there doesn't have to be an even distribution. So even distribution in a longer marriage is usually the default, but the statute is not dogmatic. The courts interpret that as not dogmatic. There are ways to overcome that presumption of equal contribution. And it's by showing, this was the intent of the parties. They maintained their own separate financial lives. Uh, they paid their own taxes. They had their own debt. One party paid the utilities and the house. Those are all things that speak to whether or not there was um, an equal contribution. Equal contribution does not mean that the spouse did not take out the trash every week or left their sinks in the left their dishes in the sink. It's not character, right? It's not like um, that person is lazy, therefore there was not an equal contribution. That is, in fact, who you chose to marry. And the court will not consider those kind of like character defects or laziness or, um, lack of emotional support as an unequal contribution. That's who you married, and that's what you're going to be stuck with. Uh, but if there's like a financial divide, then the court will look at that. If there's a very um, um, lopsided contribution, one party may be a homemaker. Maybe dad's staying home to raise the kids. Uh, that's still considered an equal contribution. Those contributions, those non-financial contributions are by statute, by law, are also considered as contributions to the marriage. So to overcome the presumption of equal contributions, uh, it's really a high bar in showing that the parties had pretty much separate financial lives. It's not emotional or day-to-day analysis. It's um, showing that the parties had separate finances, separate plans, didn't commingle to get to overcome the presumption of equal contribution. Debt. Debt is also distributed in a marriage. The thing to know about debt, two things, is that the assets of a marriage, whether it's a bank account or a home or investments, are always valued at the date of um, divorce. So whatever date the couple is getting divorced, whatever date they're in trial, that is the date that the court will use to value assets. Uh, Debt is a little bit different. Debt is valued from the date of separation. And that makes sense. One party cannot run up a huge debt and then say after they've separated after the out of the house, and then say, "Oh, my spouse should get half of that or some portion of that." So, for example, you could not commit yourself to a new Ferrari and say, "Oh, after you've separated," and say that my husband should have to pay half of that also. So, debt is handled a little bit differently for those reasons. So debt is valued at the date of separation, not at the date of a divorce. Uh, that's pretty much it on assets and liabilities. It's a complicated topic, but in some sense, it's not that complicated. The longer you're married, the more integrated and the more equally the assets are going to be divided. Types of assets could be anything from a car, the equity in a car. Equity is always market value minus what's owed. That is subject to split. Investment accounts, joint bank accounts, um, uh, sentimental items are split during a divorce. Uh, the way a court will divide a sentimental item is usually um, who has the more convincing claim to it. I once had a case where the wife, the couple lost a child in childbirth, and the wife had put together a box of memorabilia about the child, and obviously it was emotional uh, um, time and an emotional gift, and she had given it to husband. And they were arguing over that. Wife wanted it, and husband was like, it was a gift. And the court eventually found it was a gift. So those kind of cases are very specific. Um, it's not something that you like, that kind of thing is not something that could be split. It's not like photographs where you can make a copy or a video where you can make a copy. There's only one unique item. And so the courts will look into what's the better claim. Same with pets. Pets are split the same way as uh, um, any other asset in a marriage. The court will look at who has the stronger claim. So who's feeding the dog or cat or whatever, hamster, um, who's feeding it, who's taking it to the vet, who's cleaning up after it. Was it brought into the marriage by one of the parties? Those kind of considerations will go into allocating who will keep a pet. Um, uh, Debt, there's three different types of debt. There's an account, there's accounts, there's credit cards, and then there's loans. And credit card debt is obvious. We all have credit card debt. And think about it like this. A credit card is like a many-to-many transaction, right? That lots of credit cards and lots of people will spend at lots of different stores on a credit card. An account is a one-to-many relationship that like your Home Depot or your Lowe's account. Uh, those are, one store to an individual, and then a loan is a one-on-one, a bank to a person, and all of those are debts that are subject for the court to split. Student loans are um, a world unto themselves. Usually, whoever has the student loan will take responsibility for the debt if one of the spouses is guaranteed it. The court may go through some analysis about that. Uh, and it depends on, like, if it was like medical school debt that was incurred over years and one of the spouses is going to make a lot of money on that debt, that will go into the calculation of how that debt should be divided as well. So that's it about assets and liabilities. It's kind of a quick overview. So just to sum up, um, the longer a couple is married, the more equitably, meaning evenly, the assets will be split, and the debt as well. The shorter the marriage, the more the court is going to try to put parties back into the position they were in before the marriage. But that is not a hard and fast rule. And what really, really governs is what the intentions of the parties were. If the parties were to integrate, then you're going to get more of a equitable, meaning even distribution of the assets. Next topic is spousal support. I introduced it by saying future income, and that's the way I think about it, is how is the court going to allocate future income? Oregon law, or the Oregon Revised Statute, ORS, provides three bases for spousal support. The first is maintenance, the second is transitional support, and the third is uh, compensatory support, and I will walk through each of those. Uh, Suppose mom has been out of the workforce for a while, staying at home, raising the kids, traditional family, uh, and hasn't worked in 12, 15 years, and it's time for her to go back to work. The family's falling apart, the relationship's falling apart, and now she finds herself needing to go back to work. The court will provide what's called transitional support, and that is money for food and shelter and all of that, and incidentals to go back to school. Uh, it, um, it it could also be divided as transitional and maintenance, but generally an award of transitional support is for a couple of years to allow somebody to get back on their feet, to come up to a point where they're earning their market rate for their skills. And so um, transitional support is just that. It's transitional. It does not last forever. Uh, um, Maintenance support is so transitional support would be generally the way to think about it is for a younger couple. Maintenance support is generally for like an older couple where they have a long marriage, 20-year marriage, 25-year marriage, and the marriage falling apart. Wife hasn't worked or she hasn't earned enough work, hasn't worked in years. Uh, the courts aren't going, the legislature isn't going to throw wife out on her butt and say you don't get anything, of course. She's bought into that marriage. She helped, or he helped, whatever it is, their spouse um, create their lifestyle and earning potential, and she has contributed financially to that. And so um, the spouse with the higher income will pay some support on that so that the other spouse can um, have a reasonable lifestyle, reasonably proportionate to the lifestyle that they enjoy during the marriage, right? So that's maintenance support, and that could be longer term. It could even be indefinite. In the case of a long marriage, people say 10 years, but I think it's actually really closer to 15 or 20 years. And an older couple uh, may end up with an indefinite spouse support award. Um, you don't see that in young couples, in their 30s or 40s, but you certainly start to see it 55, 60 and older, where there'll be an indefinite award of support. Attorneys will tell you that the duration of spousal support is half of what the marriage is. That's not my experience. My experience is that courts will give about a third of the length of the marriage. So not quite the whole, not quite. Um, Obviously, a third is not quite half, but usually, what I tell people is, we'll negotiate for half, but if we go to court, you can expect a third of the time. The amount of spousal support is a function of the difference in incomes between the two parties. So if a husband, and I hate to use gender stereotypes consistently. I'm aware of that it's a stereotype and not real, but it's just easier to think that way. Um, uh, if husband is making ten or $12,000 a month, and wife has been making $2,000 or $3,000 a month, that $10,000 difference, uh, some percentage of that $10,000 will be the spousal support award. And every case is different, and every judge is different, and the statute does not lay out a calculator or guidelines to what that difference should be. But usually it could be 15 to 30, 35% of what that difference is, depending on what that difference actually is. If it's a bigger number, it's probably going to be a bigger percentage. If it's a smaller number, then both the parties may have trouble making ends meet. So it depends on how um, it depends on the circumstances of the case and what the actual income is. But it's the amount of spousal support is a function of um, um, what the amount will be. So, for example, if husband is making $10,000 a month and wife is making 9,000, she's not going to get award. She's not going to get support. She's not going to get, $1,000 different, 30% 30 a month. She's not going to get that. If it's, 10,000 and 70,000 and there's a $3,000 difference, yeah, then you're starting to talk about some spousal support. Where there's no question that wife will, or one of the parties, the lower earner, will earn um, an award of spousal support is where it's significantly less, less than half or a third of what the higher earner is earning. That's when you'll start getting, you know, spouse support awards, and the certainty of the award, the certainty of getting the award goes up. Again, the legislature doesn't lay out how much should be given by the court. What it does do in both transitional and maintenance is that it asks the court to delineate the reasons for um, for the award, and those reasons are the skills and training of the parties, the lifestyle that they maintain during the marriage, whether or not one of the spouses has child raising obligations. Um, so that's the kind of things that the court will look at in determining um, those are the criteria that I should say. Those are the criteria that the court will um, look at in determining um, how much support to give. And so the two factors are, just to recap a little bit, the two factors are duration and amount. Duration, you're not, unless it's a really long marriage, 15 years or more, it's probably not going to be, and the couple's older, is probably not going to be indefinite. Um, uh, and you can figure a third to a half for the duration, and then the amount is going to be some percentage of the difference in the incomes. Some other factors that come into play are does the couple have income producing assets, right? Those may be considered as part of a spouse support award, or whether or not one of the spouses is receiving a greater share of property in lieu of spousal support. A lot of couples will do that. Um, or on the flip side, supposing one of the parties is disabled, supposing the receiving party is disabled and receiving Social Security disability benefits, um, that may you know form an argument for longer or even indefinite spousal support. And if the um, so if somebody's not able to support themselves, obviously that's going to weigh on a judge's mind in determining duration and possibly amount. Uh, spouses Social Security benefits cannot be garnished, right? So you can't tap a bank account to recover Social Security benefits. So those benefits are never part of the Social Security the calculation in somebody's amount that they have to pay for um, spouse support. I think that's it. I think that's the whole talk on spouse support. It's not actually. I just remembered. I want to come back to one more criteria or basis for spouse support, and that's compensatory support. And compensatory support is different from transitional or maintenance. Transitional support says that is appropriate when one party has bought into the future income of the other. So, for example, and this is like the stereotypical compensatory support award, wife works to put husband through medical school. She's bought into his career and his future income. She owns a part of that income. She owns a part of that income stream going forward. So compensatory support is um, to compensate a spouse for their efforts in the marriage early on, or maybe it's not early on, but to compensate for their efforts uh, during a time when one of the spouses uh, couldn't work or um, needed the support of the other spouse to earn a greater potential. Uh, you don't see compensatory support too often. It comes up occasionally, but the other two, transitional and maintenance, are pretty common. Not very common. They are the common reasons for support. They can be combined. A court, excuse me, could say, well, I'm going to give you transitional support in the amount of $2,000 so you can go, so that the spouse can go to school. And at the same time, I'm also going to award you an award of $3,000 a month so that you can support yourself while you're in school. And we'll continue the maintenance award for some time after you're working. So the transitional support may go for 2 years and the maintenance support goes for another 5 years. That could happen too. So there's some creativity in how those are awarded. The statute allows that and it's done. Okay, done with spousal support. So let's talk about the kids. We talked about assets, liabilities, we talked about future income and spouse support, and now we're going to talk about um, the children. There are three issues with relating to the kids: custody, parenting time, and child support. Custody means the right to make a decision over child's welfare, right? It doesn't mean possession. It's not the right word. You'd think all these smart lawyers would come up with a better word for custody. We haven't. Custody, like you think of custody, like this person's in custody now, right? I have custody of my mouse from my computer, uh, right? That's one meaning of custody. In this particular context, custody doesn't mean possession. It means decision-making right, the right to make decisions. And so the parent with custody makes decisions on where the children or child will go to school, where they'll go to church, synagogue, or mosque, uh, um, uh, where they'll get their medical treatment or what medical treatment they'll ultimately decide. Uh, the custodial parent is where the buck stops, kind of like the CEO of the marriage. So the offset of custody is parenting time, and parenting time allocates where a child will be at any one point in time. And so we all know the typical standard parenting plan. Child is with dad every Wednesday and every other weekend, and mom gets the child for Thanksgiving, dad gets the child for Christmas, and they switch every other year. That's still done. It's not done as much anymore. People try to come up with more um, parenting plans that are more specifically geared towards their kids and their kids' interests, and the parents having more meaningful involvement with the kids' lives than just the every other weekend. Uh, but custody and parenting time are two very different concepts. People confuse them often, but to lawyers, they mean very, very different things. Custody is the right to make decisions. Parenting and parenting plan, parenting time is where the children are at any one point. When a parent, when a child is in um, the one of the parents' other's presence, I'm not gonna say custody, in their presence, um, that parent has the right to make emergency medical decisions where the child is going to do what with the kid during their parenting time, what sports they're going to do, all of that stuff. If supposing mom says the kids are going to be raised Catholic and the husband is Jewish, and the husband wants to bring the kid to Shabbat services on a Friday night, it's his parenting time, he can do that, even if the mom says no, kid's going to be raised Catholic. So, uh, um, dad, in the if dad had and if the kid went to services and fell down the stairs, dad obviously would take the child to the hospital and could have emergency, you know, medical decision making power, even if he doesn't have custody. If like the doctor says, well, you want to set the bone, well, obviously, dad's going to say yes, and has that authority to do that. The other thing that dad has is the right by statute to receive uh, medical, educational, counseling records for the child. That unless the court takes it away, that's the non-custodial parent's right to always have that kind of information. So that means that even if mom's got custody, if dad wants to go to the PTA meeting or a parent-child conference, um, uh, dad can go. Dad's got access to that information. So um, Uh, that's the custody and parenting time. In Oregon, uh, there's two types of custody. There's joint custody and sole custody, and that's it. And sole custody may reside with mom, sole custody may reside with dad, but it's going to be one or the other. If the parties agree, if there's an agreement between the parties, then they can have joint custody. And joint custody is appropriate. Like, I've seen plenty of relationships and divorces over the years where the couple's just not getting along. Like the marriage is just not working. There's, too much resentment and there's no intimacy and on and on. And the couple, they're just done, but they still parent well together. They still share the same hopes and dreams and aspirations and values for the kids. And they still operate as a couple when it comes to the kids. And in situations like that, um, joint custody is perfectly appropriate. And um, I've seen that plenty. I've seen that that scenario plenty of times where the couple is still they're still good parents. They're still good parents together, even though their personal relationship. And I've also seen that those people, once the drama, I don't want to minimize by saying drama, but once the hard feelings and the resentments of the divorce die down, they're usually able to find some equilibrium again and, come back to, what drew them to each other in the first place. They kind of, a lot of times will rekindle that and they will parent well together. And uh, joint custody is perfectly appropriate in that circumstance. Joint custody is not appropriate where there's been abuse. Um, in the marriage. And if dad's the abuser and um, mom gets custody, she needs that decision making power and has the authority of the court to make those decisions. She may not choose to do that, but the parenting plan is also a rule book, and it says this is what we're going to do for the kids, and the court will enforce that. And the Oregon legislature has thoughtfully provided a efficient mechanism to enforce a parenting plan efficiently and much more easily than any other provision in a judgment dissolution. So um, um, that is custody, the joint and sole custody, and then there's the parenting plan, and then there's child support. Child support is mandatory unless there are very specific circumstances, like somebody's in jail, or the parties have enough um, assets individually that they don't need the support of the other party. Uh, in those circumstances, child support is not required, but child support is mandatory. And Unlike spousal support, which is a negotiated amount, right? That, like I said, the legislature hasn't given a formula for calculating spousal support. Child support is a calculated amount, and you can go online to the Oregon Department of Justice website, and you'll see a tab for child support, and then you'll see a sub-tab for child support calculator, and you put in your income numbers, you put in your spouse's income numbers, you put in number of overnights, you put in childcare expenses, you put in number of non-joint children, you put in union dues, you put in cost of your health insurance, the cost of the child's health insurance, and with those inputs, um, the calculator will get back a number, and that's the number. That's how much child support needs to be paid. And so, mercifully, it's not a negotiated amount, right? It's just like this is what it is. People argue over the inputs, of course. I don't make that much, or yes, you make a lot more than that, or they'll argue about like how much is legitimate childcare costs, uh, um, but they're not arguing over the formula or whether or not it's going to be paid. It's going to be paid. So child support's usually once you get the inputs established, it's just a matter of putting it into the child support calculator found at the Oregon Department of Justice website, and that gives back a number, and that's the amount of child support. There's a couple different ways to get child support, even if a couple's married and like somebody's moved to another part of the state or is just like not around and not contributing. You can go through the Oregon Department of Justice website and open an account and say, I need help collecting child support, and the state will do that, and they're usually pretty good. They have a lot of tools to find people and to collect money, and a lot of pressure points to get people to pay money. For example, taking away or suspending professional licenses or driver's licenses or capturing tax returns. So, uh, tax refunds, I should say. So, there's a lot of power that the state has to make sure that child support is actually paid. Uh, so, it can be paid through uh, Department of Justice, it can be paid through a county's district attorney, or it can be paid by filing a petition with the court, and the court will rule on how much is owing once the inputs are made. If there's a that can be handled as a standalone case in the court, or as part of a divorce case, or as part of a custody case. Uh, and it doesn't matter which type of uh, mechanism you use to get to the number. It's going to be the same. You're going to look to the Oregon um, child support calculator to figure out how much. I often advise people if it looks like it's going to be a long way before the divorce gets filed, or somebody is in real need of money now, to just go ahead and start the child support account at the Oregon Department of Justice or at the DA, and let them get it started. And then, if the case does go through the divorce process, you can update those numbers later as part of the court case. What else can I tell you? Um, I think that's about it. That's so we covered assets and debt. We covered spouse support, and then we covered the children. The children are custody. We talked about joint and sole custody. We talked about um, uh, parenting time and how that works, and then we talked about child support. I will say one more thing about parenting time. Uh, the Oregon Judicial Department has a forms bank for people to use. You can fill out downloadable PDFs, uh, and there's a really, really good form that the state developed for parenting plans, and that's what I use when I have a couple that I'm mediating with them as opposed to litigating. I'll have them we'll work together to fill out the parenting time plan in a way that works for everybody. And this one particular form happens to be very, very good and covers a lot of details that, a couple might normally miss. But that's if you're like working with your spouse to get together the parenting plan and you want to do it together in a fair way and you can talk, uh, that parenting plan is really good. And you'll find it just by going to the Oregon Judicial Department, and then you'll find a tab that says family law forms. So I think that's it. It is about 22. I've been talking for about 40 minutes. So thank you for attending. If you have questions, please feel free to give me a call or shoot me an email. I'd be happy to talk over your issues with you. And again, it's Stephen Leskin, and my website is www.leskinlaw.com. So thank you for attending, and have a good evening.